Mame fa say ma PENDREAM TV. PENDREAM TV de o se dem yopo.
Ka chama Wontumi case no baako judge no are making the indication set 3rd July what the judgment beba before that no she won say obi am file addresses famra on or before 17th and anu kwa the osatwe mu the 24th of this month na we enoto nchen enum ne bete say lead counsel no honorable Apia Kubi ebe kan say no or twene ho e de afiri mu wo twene ho afiri mu so twene afiri mu no judge ne kan say omumra sem no so enua no judge ne kwa no say he must come the proper way nti said you see ade no ye will lay down procedures in our jurisprudence no say ni na tie ye wa Apia Kubi so ba bonte be kan say Niama na judge ne kan no some of them are alien to our jurisprudence na no so hun komo ho nti yantwe afei se wabesa akobie mu na kwotwe ne ho afiri mu officially no yet yes say wo ma appointed yewa attachia so make the indication say obeji proceedings na hwe na wahwe kwan a obefa so e de ebeye and then when quizzed about the obeye no was say eno de one funny strategy and tudwa na ahana mi bisa say baby a case yedrui can the new lead counsel no arrest the judgment of the court eno eye ba ko din kan can the lead counsel no ebetimi appeal to a higher body say sabre ya wa bay wo he proceedings ni mu no aha nkoye enti maybe the case is closed and the no kra no close court be higher court no makwan ne open ne bia yenye cross examination be a yen lead will be in evidence yemfa enom emra because na nipa bi so argument ye any say bibi say case management conference no ye ko fa free civil jurisprudence mu ene ye de aba criminal jurisprudence mu enti no nka we no kwa new phenomenon wa bi a ke betumi aye ne aba benya a case law on that and a precedence in law enkomo we ye de ye nimu mra say na abeka no
yo once again back when meda was na meda Ghana man pedi President John Dramani Mahama I say one of the things President Mahama aye and then is or the idea friend Mahama ke and then is yare bi ono ma ye from non-communicable diseases hypertension diabetes blah blah blah. And no, President, even the cancers in our President Mahama, yes, say one of his legacies also on the Mahama care, the Mahama care, particularly those are to me and afforded the treatment of these non-communicable diseases. No, now President Mahama, as leadership is always by example. Ntionwa dedicated part of his salary as money for this initiative. In what I say appointees in so in fact on my deadline say you submit an asset declaration document. So can I say the moment to me as I am providing more asset declaration document before the deadline. One more be also be losing his salary. All of this thing is going into this Mahama care. Meno cases is here now. I yielded over 6 million Ghana cedis from appointees. The Akoma, the administrator of this Mahama care. President Mahama Nakuma Pa Obia or Drain Ghana for Timamu for na other side way Ediaba. And then appointees contribution and your one salary. 6 million Ghana cedis in a Ediegu this initiative. Inti ene eyadea adusum kwa President John Dramani Mahama ya enyapa setimemufo people say sebe vote na omotoma no the unprecedented number of votes are omodema no Sebio, he does not take it for granted, and you do everything to make their conditions better. But when Marcus asked them, we are here, no, and then you better call a bit of law school. Now, a bit of evidence law. A bit of criminal law and procedure. Now, I should say, how is criminal justice delivered?
How is criminal justice delivered?
It's important. Now, maybe said you for the past October, then I would have been doing this work for 13 years.
Oh.
Yes. Me area pa managing hopa a criminal law. Managing hopa. And the reason why I manage criminal law, and in fact, one of the persons that Emma me developed that strong interest in criminal law, a lawyer Kitty Jabin, or chair me criminal law at the law faculty, or develop it, or mommy develop that interest, because it's the easiest part of law practice from defense.
As compared to civil matters.
Yes, because when we say civil matters, so lawyer, I think I'll be prepared with pleadings, obey your statement of case. Obey. But criminal law, there we a defense lawyer, and one is so sorry our court. Prosecution saying they are the witness with, but one is so court now you are taking notes, cross examination. Only do witness you are then you just do your cross examination our court. That's how it is. So for me, from practice point, I think that is the easiest part of it, and it's a very interesting thing. Look, when we say the English law, one of the biggest interventions in the English law is the concept of reasonable doubt. Is the concept of reasonable doubt. Reasonable doubt, you can't reasonable doubt, and it's the same. In Joshua, every which means evidence by court. Hey, wait there, assembly baby, no say judge, I can say not guilty. No, be a fool. Why would you say that the person is not guilty? We saw it. This. Because there is something called reasonable doubt. The lawyer for have been able to raise the effect of reasonable doubt. Say, I didn't know. Yes, one you. Yes, say, one you. Oh, sir. And yes, I in your class or bed of the prison. It is annual money in Naya Day. Abuama yet me organizing in terms of the English criminal law. Now, a few things have happened recently. It makes
the English criminal law and then the common law. As started here around 1066 or thereabout. Yes. Okay, history of common law. And so the womb kakra.
One we say compared to civil law no Roman 4 in the buy. Roman 4 in the buy. And then I be the core, jurisprudential basis of French law and But the English normally introduces the idea of common law founded on precedents.
Adebia esi painti.
Precedent. Adebia esi painti. It is a esi painti. And the bit me using the biome. Now, one of the most important organizing principles. In the English criminal law is the presumption of innocence. The presumption of innocence. Into this hallowed principle of criminal law, and not the idea, but Article 19 of the 1992 Constitution. A person is presumed innocent until proven guilty, unless the Onankasa pleaded guilty. This important fundamental principle of criminal law has received constitutional elevation in Ghana. It started as common law.
Proving guilty before a competent court of jurisdiction.
Competent court of jurisdiction. What it means say anything extrajudicial is forbidden. Mob justice is forbidden. It's completely forbidden. Now, Brakwame said you, Chama Wontumi, and I always say this: hard cases make good law. Hard cases make good law. I'll tell you.
And kakra.
What we say, maybe not me, National Communication Authority board members be 2017. A Bible from no buy and almost investigate over some cyber security transaction be. At the end of the day, no board chairman, MD, 2 of the board members, any businessman, 5 accused persons, the call court and charge with various criminal charges. I happen to be the lawyer for the 2 of the accused persons. Now, Brakwame, I'm not near yes, our case, no. You're court, but you're telling you, you do court, no. Now, prosecution, the witness, haba. Now, witness now, the bebano. Save you, a dear prosecution, you want you need into almost start here. No, and then almost the board minutes at the bar. Almost the board minutes in the bar. Now, judge may be saying, counsel, do you have any objection to the admission of this document or evidence? Now, yes, so my lord, can you permit us? I think you call your client in open court. I could be someone say, now there are prosecution for the bay. Yeah, object here now, yeah, pencil man in court. True. It's one Sunday, and I may friend, my colleague, other lawyers, and I may say, hey, try a year air cosi, a year sebi. I in fear kind of trial, just. If we are not careful, we will not be helping our clients at all. One, I mean, 2 other colleague lawyers, no, yes, and the Sadia many application for discovery. But you application for discovery. Now, application for discovery, no, me per se evidence be a prosecution, no, a war, no. I want to know ahead of time. So that I can prepare adequately. And I mean 2 other lawyers and I can say, okay, they support me. It's a Sunday. Me by office now me be ye bibia me ye no. Incidentally, I say more. And I may send me the draft at the current Deputy Attorney General, Justice Frinsai, the area power human rights.
Oh no.
Yeah, that is area power human rights issues. Me said that same man and say, look, this is an application I want to do before this judge in this matter. But I want a perspective on it since the area power human rights. Into me ohana or send him in a comment. And also I think said the time has come for the court to bring finality to this matter. So you encourage me to proceed with that application. Monday morning, and I may file a Tuesday, Sano, not yes, our case, no, Tuesdays and Thursdays. If you go Tuesday, you from 10 a.m. to 2 p.m. Near about Thursday, 10 a.m. to 2 p.m. Every week, we are near 8 hours every week. Jaso. Yes. NCA matter, no. We did it before, my Lord.
Sad time
you come twice every week, Tuesdays and Thursdays. Now Tuesday they started from 10 a.m. near upon 2 p.m. 4 hours continuous.
Wow.
Every week they are near 8 hours continuous. In a year. It may kind say, you call court on a Tuesday, no, I may say, my lord, so my lord. Cross examination, yeah, media application, media back, it may show any deal. Penisona, me moving my application because me are sure say, what yemia, ebia, ebeboa, and I'm a lord. So the business for the day Tuesday, no, it's not for that motion. Because on the face of the motion, almost a Thursday, now I'm so my lord to make train in the bad Thursday. It's a bad Thursday. I tell you, at that time, yeah, my Gloria Kufu. I can't show on any yachting. But you knew, say, may ask for disclosure in that criminal matter. And according to her, or say, first of all, the trial is a summary trial. Your criminal procedure, so there are two modes of trial: summary trial and trial on indictment. Indictment, no, I assume that any rape, any no. If you are trying them on indictment, obey the FED, obey magistrate or no. A small trial be or magistrate or.
I want to find committal proceedings, you know.
Committal proceedings.
Okay.
It's all committal proceedings. No, judge no committee will be. Evidence now will be shown to you. Madam, you are me Gloria.
Yeah, I want to establish a bill of indictment, you know.
Bill of it. So the bill, no, what is called the bill of indictment, include a summary of evidence so in that bill of indictment.
Okay.
So in this case, make I know. Gloria, that day on no back court, but one argue on one of the senior attorneys, on no plan a criminal procedure, Madam Evelyn Kilson, on a chairman. In fact, in my two next criminal procedure, Yvonne Tamakloe Bobisa and Evelyn Kilson, Yvonne, on any director of public prosecution this year, I'm going to chairman. Incidentally, that day, in back court. And jokingly, almost can say, Edudzi, that's why we taught you in law school. You know, we told you that in a bill, trial indictment, we will give you a summary of the evidence, but summary trial, no, that's not what we taught you. In the head, say, and see, me moving the application every year. In the professor, Madam Evelyn Kilson, a opposing application. The Kaipan said the affidavit in opposition was proposed to by one senior state attorney, Richard Jambidi. And I reached the council in the deposition. Was that be? As someone made it to judge, that's not the position of the law. And that Criminal Procedure Act, only has two modes of trial: summary and trial by indictment. The disclosures now would have happened if it was trial by indictment. Na judge say, yeah, man, I'm ready. Obeko, Edini ruling about. Now, come lo and behold, my Lord Justice Chebafo, ever back now, say no. But raising a very serious constitutional issue. Because me man who say, Article 132, no, I can say, in the course of any proceedings, if an issue of interpretation arises now, you have to stay the proceedings and refer the constitutional issue to the Supreme Court for interpretation. You know, say, look, I've raised a sound basis for the matter to be referred to the Supreme Court. It is based on that application, in my Lord favor for making the order for reference to the Supreme Court. Supreme Court judges now almost not very progressive-minded Supreme Court judges. Almost say, look, we have raised an important matter, and that the time has come for us to change that rule of law. And no, in the Ghana, the Supreme Court, for the first time, I can't say, in every criminal trial, whether summary or trial on indictment, you must disclose the evidence. Prosecution must disclose
and I'm also na sa disclosures yi Supreme Court no share say yenye in our jurisprudence.
Make it sure. That is what fundamentally changed the law. In fact, you can look at.
As me know the I know you as my adversary, yes. Whether the Republic or whoever. Now the owotia me no ehon tumam. Wo ba ye na wo yesha me kon. Be a first time kwa me who document no. Na me come asem say.
When you say my lord just for. I still remember vividly the argument. Maybe say my lord. The heading of Article 19 a fair trial. That's the heading, no. Fair trial. Now, imagine this situation, no. When you be babeku. When you be babeku. And now, only panel are blindfold you. Or the blindfold at the teaching with him. And now, answer wow. On Sansra, over to talk at Ransom. What is your on Saw with you? You must see him. Brother, meet you.
Meet you.
And a corner Babekono, or say a fair. Maybe some my lord just for. I say, my lord, with the greatest of respect. Say, you're blindfolding me. I don't know what I'm coming against. And yes, young cool. No, say no. This one, dear. He believes a strong case has been made to refer the matter to the Supreme Court. And anything an American say, hard cases make good law. Hard cases make good law. Meaning, say, if we had not taken that initiative, and you can't say your client, so the disclosures in criminal matters. In fact, you can look at the decision. Eugene Bafo-Boni, the Republic versus Eugene Bafo-Boni. That's when the Supreme Court made that decision. It is based on that, and a Ghana Chief Justice at that time, Sofa Akufu, I can say, based on this decision, no, or the kind of practice direction in criminal trial, Edeba. And that is what has governed the conduct of criminal trial since 2018. And then, case no, our district court disclosure will be done. Circuit court disclosures will be done. It doesn't matter.
I would be there dance yet. I mean, the old war a shown to me. My name's Ruby. Na me ba me dia nu yaba.
Na me ba me dia nu yaba. Who did this thing to your chest? Sabi. And one of the things Mr. Kache, my Lord Cheba for Crown, and I think that it was one of the things that convinced him. I told him, I said, look, my Lord, when disclosures are done in criminal matters, the benefit is not only to the accused. The benefit can be to the prosecution. No, besides, we say how. I'm saying, my Lord, with respect, Sekobo says, accused person, you know, said you will move the quality of evidence of prosecution over Tiana, what because they with your mama Mensaso. Mama Mensaso, I will plead guilty. Meaning, they provided the foundation for a plea bargain, you know.
Okay.
Because you see, the benefit is mutual. It is both to the accused and it's both to the prosecution. It is accused person who the quality of evidence against him. Or also to make us say, I won't waste the time of the court. My Lord, I am guilty. Prosecution is an expensive enterprise. What disclosing a bois? Now back to this Chairman Wontumi away, no. Sebi. An important issue has been raised. A case is filed or charges are filed at the registry. It is served on accused person. Accused person, the first day in court, arraignment, or say, look, my Lord, I'm not guilty. And Obian himself, the fact accompanying the charges, no, does not constitute evidence. Unless the accused person make a guilty. In this particular case, accused person will say, I'm not guilty. He's granted bail. Okay. Then, almost 2 months, case management. Yebeko say.
Councilman Musa, Meti say Honorable Apia Kubi, lead counsel for Wontumi can say case management no no na it was civil jurisprudence mu, so it was smuggled to criminal jurisprudence. Na no no is not found in our status. It's alien to criminal jurisprudence, but it's become an accepted norm.
One will say the issue of case management became the center of the Supreme Court decision in ex-parte Dr. Kwabena Dufo. And then they say in the Kwabena Dufo matter, no, at the case management conference, no, judge, started taking objections. Documents way, documents way, Dr. Dufo said that the judge only who going to take that decision because Section 6 of the Evidence Act say at the time when the evidence is being offered, that is when the question of objection or otherwise can be taken. To the extent that who judge was taking objections on admissibility prior to the time the documents will be offered, you have infringed or violated Section 6 of the Evidence Act. The Supreme Court said, your name, Dr. Dufo, Eye Akeyi. And on that bed, I need the case law now, ex-parte Kwabena Dufo, doctor. And yes, question of admissibility or otherwise, it can only be taken at the time when the evidence is being offered. So case management, for me, is just a housekeeping mechanism. Obi bia atutu na namu iya na documenta o se o no no krese o di atre defense for na has the accused person been said. So the whole essence of case management is just for housekeeping. Any useful purpose beyond the housekeeping, because even objections cannot be taken at that point based on the ex-parte Kwabena Dufo decision. And the most important thing I think which is playing out now, and it's going to be a tall order in terms of the received learning. And I say hard cases make good law. This is the case, said you, the accused person is represented by a lawyer. The lawyer is not a mean lawyer. Several years at the bar. In the prosecution, at the 4 or 3 witnesses at the bar, in fact, there was a day now there was an issue about the lease, whether or not there was a lease or whatever. An objection was taken. Judge no ruling in favor of the accused. Mekaisa Misinia and the Pia could be Babonti. I think I have the video recording. Praising the judge.
Yes.
This decision now, judge not taking a very important decision. Fast forward. Prosecution. I can say you're closing your case. There again, Messinia Andy, based on section 174, or say I want to make a submission of no case. Now, if you look at the Supreme Court decision, the earlier decision like Republic versus Ali, Kasina, and the rest, there are rules on the basis on which a submission of no case can be made. The most recent one being the Republic versus Michael Asamoah. Our Supreme Court go back to the 1950s, 1960s to look generally at the law on submission of no case. And will say, Teniyo, in fact, the judge is not even bound to give you the opportunity, Teniyo, to say, I want to make a formal application. Or she may. The judge may discretion. But in this particular case, no. Accused person is not going to say no. from all the evidence that has been put before the court by prosecution witnesses, and based on the totality of cross-examination of they don't feel say a prima facie case has been made. The court, the Supreme Court has said, even the judge, immediately the prosecution says they have closed their case. The judge so much can say, I've made a determination, there is a prima facie, open your defense. But in this case, the judge didn't go that way. He said, no. When there's a formal application by the lawyers to make a submission of no case, they should be given that opportunity. Now, guess what? Accused person and then a lawyer for copious submission before the judge that, as far as we are concerned, a prima facie case has not been made. And a judge said, no problem. Or no court now has shown a ruling or say, based on the evidence I have seen, based on testimonies, sworn statement, unsworn statement made by accused person, made by other persons, prosecution witnesses and others, I think a prima facie case has been made. I'll give you this opportunity or time. Prepare and come and open your defense. And no, the lawyer didn't open their defense immediately. They brought in an application. They quickly filed a notice of appeal and said, judge, ruling on the submission of no case, no. But it's you. Make a decision. They will take it to 3 judges. That's the Court of Appeal. Based on that, almost file a different mistake of proceedings. Say you file a notice of appeal, you best apply to state proceedings.
There's a high court in the entering train, so. Kopim say, Ganakobia court, no, ebe ruling on application, I'm going to call home.
No cre. Yeah, we. Yeah, quickly. Yeah, then. Aha. It's only the Kobai. Almost came before the judge with the stay application. And and almost call back to the Court of Appeal. The Court of Appeal. We have filed at the registry of the High Court a notice of appeal. Judge, say, Obekoso for us to open our defense. Court of Appeal, yes, sir. Stay the proceedings. Let Manu Kwai and Manu name. Because the basic principle of law is that a notice of appeal does not operate at a stay. So, almost the formal application at the Court of Appeal say, Court of Appeal, no man who can and man continue the also obey. And a Court of Appeal, defense lawyers, accused person, you go and open your defense. Go and open your defense. Now, let me give you an analogy. And then they are school. And now my name is Senior Dr. Bassett. Here representing Honorable Atuforsen. A similar thing happened. Prosecution affair of witnesses. Prosecution affair of witnesses now can say they have closed their case now. We made a prayer before my Lord, my lady, Justice Fiasawa Oche. And you can't so, my lady, the president here is submission of no case. So go ahead in the year. Now what did we do? No. And now, apply for. Submission no should that be. Only an she believes but just telling you a prima facie case had been made. And as far as Honorable Atuforsen is concerned, we have to open our defense in respect of the 2 charges. Yankasa. Unim, I'll tell you. Immediately, my lady, they say no, will not apply to stay. Okay? But will appeal that decision. Until you file notices of appeal. And respect of the 2 counts now, or CMB opinion, the defense now. Immediately, I mentioned the senior, Dr. Bassett. Man said, senior, I did see, I can't see a big change. The court people who say, on the compile the records of proceedings at the Amayana. Embassy. It's Nyankasa Meko Court Honor to follow up on the compilation of the records. It is the court clerks also daily. The only here to do photocopies, Nana is normal. So, Mr. Brafam, you know what happened?
Debbie.
Within the shortest possible time, I compiled the entire records, about 4 volumes. I compiled it all. By which time we had opened our defense, near colleague witnesses, near colleague witnesses, near colleague witnesses. In a year, then Richard Japa also started calling their witnesses. And before Richard Japa,
Counsel, I hear you know. Minim say I nebi or more free witnesses of fact and with expert witnesses. One would hear in the mood drew an above ring in a
The most important one is the witness of fact.
Witness of fact, okay.
Because no, one will say your Bible class the yehuno. The yehuno, and when you didn't want dance here, yes, and a Bible canon.
And a Bible canon.
But the experts, no best me but no have provided expertise. Let me give you a classic example. Okaya and Ra Abai say on the prosecuting Pabna Meni
Tago
alias Tago. Almost fair police for investigators as the witnesses of fact. No. No mo ko fa papa bi efia brochire e de baye woni mo hwan
Abio
they did the Professor French. Professor French became an expert witness on the audio recording.
Hey, sak akofa asembayo
Odi amekaba on the audio recording. Ono no be ye expert witness. And that answer why Omukofa Professor Kofiya Jekum.
Yeah, Pania Jekum of Peace FM Legon.
Department of Linguistics. It was also by as an expert witness. And the nature of his expert testimony in say on the audio recording, you know, say Niema, because they were speaking the Akan language on the audio recording. Into know as a professor of linguistics, no. Omra, no match record, no. The translation. I can say me a can yema. I say me today. Professor Jekum became an expert witness. In this case, the expert witness no mo de buy a branch now almost I think the something Gomashi. Onuno by as an expert witness. That is field of study.
Make I say a lawyer and the appeal could be crab bonteno. Okay, but sa expert witness na basu say what the aqua school or court or pa.
Exactly. And all this while, no Missinia, the appeal could be had never raised an issue of the proprietiness or otherwise of the trial. But what here?
Chupa.
Two. Even more important, if you follow the trial very well, there was a time accused person, what can I say? Or a few of his witnesses in the buy. Or the buy and I tell you, look, my lord, the rule of law is simple. The rule of law, and say, when an accused person is offered or ordered to open his defense, no one open his defense now. The rule of law, and then say, once a prima facie case has been made against him, it can be the basis for the person to be convicted. If you are telling General Bar, Deputy AG, and by judge, no, I don't say judge with respect. You've offered the accused person and you've ordered him to open his defense. He had failed to do that. So we have an application for you to commit and convict the accused person. Again, lawyers for Wontumi say, no. Judge me say, no, I won't allow it. Permit him the opportunity to open in a judge in a man of time for him to bring with his witnesses. All this while, accused person and his lawyers didn't say anything. Almost started the witnesses at the bar. No more. Brother, all these things have happened. It's again no over Bontina Obeka say. The judge has not been, the proceedings have been some way. This. The rules are supposed to be fair. The rules are supposed to be fair both to the accused and both to the prosecution. Because you see, prosecution is a public policy tool. What I said, prosecution is a public policy tool. It is to serve both the accused and to serve the anything I will say, it is called the report and the person. It means that the benefit is both to the accused and both to the republic.
A mutual
Benefit. Whereas you are protecting and safeguarding the right of an accused person to fair trial, you are also mindful to protect the interests of the republic. In this particular case, and you say, I will plead, let's say, the senior Andy, and we hear a commentary on this matter. And what's in the commentary now? Sebi. It gives a certain impression, say, the reason for the withdrawal, because the judge, quote unquote, has misconducted herself, or the court has misconducted itself. However, it is basically to offer the accused person maybe a second bite at the cherry. That it is all a strategy to give the accused person the opportunity for a second bite.
Okay.
I have to say, Obia Wakocho law exams. Odu law exams, case law, When we say law exam, case law, the editor, it also comes with the aid of decided cases and statutes. How would you help on these facts or scenarios? And I would do law exam. There are two important case law to help you solve that problem. And I was saying, the refi. The refi case you.
Oh, but your law exams pana refi re akuto.
Aha. And I was
saying, pass say.
Anna to for an attorney general.
To for an attorney general.
Constitutional law. Now show refi GH Mensa versus attorney general. Also refi MPP and IGP or MPP versus GBC. These are locals. They are the earlier decisions of the Supreme Court post 1992. So those cases, there, as a law student, you must have it on your fingertips. And how come you now buy now? So that you the way fee. But examiner, Miss Law, a man like him. But there might be opportunity. I mean, something I mean, show paper. They say, my 2 cases, no. Rakwame. What do you make of it?
Cause you run it up. Na ya famedru baby a say with Kennedy what Andy what twene ho afiri ho na ye attach yan so eba na attach yan ben so day na obey what I'm in his sleeps concerning issue judgment is set to be delivered in the 3rd July.
Sebio, my senior honorable Samuel Atachia. This is his trade. Waye Jumaya Chepa. Sebi. I will never, not for anything, underestimate the legal Juma Messinia Atachia Aye, very respected lawyer for that matter. On one is different strategies. I'll basically apply. But it has been said, sir, Ebia Oba, Obeche Judge, no, since Oye new lawyer on record, no, lawyer, no, a man and rare, Obi Okra, Obetnia, bring an application to recall witnesses, Obetnia away. So, in terms of the options and the strategies, no, lawyer behind the strategy. Lawyer Bia. Aha. And you know, the coming days is going to be a bit of an interest. It's going to be a bit of an interest. So let's leave it. Thankfully, they say Momu or court reporters at the Biomoko court. They'll report accurately to us the Akosu of no. And we may want to interrogate them further without prejudice to any of the parties.
Council Mamma was not saying I'm Pampa. I mean, sir, yes, you will do a full crown, me fair week.
One we say, Sebi, and then President Donald Trump will say only Iran for I enter into an agreement which will see the reopening of the Strait of Hormuz. Strongly, we believe that it is going to impact on the price of petroleum products globally. Before the war, now a metric ton of diesel was about $695. A koya, when we say a koya could pay $1,300.
Hey, a double over 100%.
100%. We know because crude is now hovering around $80. At a point, it went as far as $120.
Wow.
Strongly, we believe that in the coming days, there will be greater comfort for petroleum product consumers. Now, with the Ghana man, President John Dramani Mahama, who cares for the people of this country? And the cabinet intervened in April to ensure that instead of petroleum products doubling, or say no, buying, they intervening with 2 Ghana cedis, 2 cedis, to lessen and mitigate the impact for the ordinary consumer of petroleum products. Sebe, manya kwenye na as you say, menda Ghana man penny asset to all drink Ghana for, and then things are normalized, and they have normalized to the point that we have gone back to the status quo, and prices of petroleum products are still relatively cheap. Meda Ghana man penny asset, and then the cabinet, and this an amount to no 2 years with my able sector minister, the Honorable John Abdullahi Napo. Mekaise media at the end of Baye said this is a directive from cabinet. My board chairman, the Honorable Alhaji Wudu Yaya. I said, look, the president says, and this is the directive of the president, this is the directive of cabinet. We must go ASAP to ensure things will be better for Ghanaians.
Mamena was a pa.
Dedi kama Mamena PENDREAM TV ase. Now so far so good. Say open online portal e wo Ghana. Nipa share, nipa follow, nipa comment here. To my best of knowledge, without any biases, PENDREAM TV.